if your partner dies and your stepchildren were in their primary care, what happens? So this is a complicated legal matter because there's no one simple straight path to the answer. The outcome is going to rely on considerations under family law, succession law, and potentially domestic violence and child safety laws, depending on the parents and the circumstances involved. Things that can factor in to what happens to children after the primary parent passes away are whether the other legal parent is still alive, whether the other legal parent is willing and able to care for the children, whether there are any family court orders already in place and what they say, whether there are child protection orders in place and what they say around the other parent, whether there are domestic violence orders in place and what they say around the other parent, whether the primary parent who has deceased had a will, whether the deceased parent had appointed a guardian in the will, and what care arrangements would be in the best interest of the children. So there's so many different scenarios, but I'm just going to go through a few things. So there are instances in which you may have been one of the primary carers of the children. The will appoints a different guardian, and the other parent who was previously estranged has come back into the picture. The main thing to remember is that none of these people have an automatic right to primary care of the children, and all the parties will need to work through the necessary legal processes to have parental responsibility or legal guardianship rights appointed to them. Although the other biological legal parent may hold prima facie, on the face of it, they may hold legal rights according to their name appearing on the birth certificate, they may be prevented from having contact with the children under another court order. You may have been a primary carer, but perhaps you had a poor relationship with the children, or it was only new and recent, and maybe they have another close relationship or connection with a previous partner of the parent or an extended family member. The guardian under the will may not want to have care of the children. Maybe their circumstances have changed since the will was drafted a really long time ago and they just can't have the children anymore. The best course of action is to seek urgent legal advice around your specific situation so that you can determine the most appropriate path for you and the children involved legally and for the best interests of the children, prioritising the needs and interests of the kids who have just lost their parent, because that needs to be at the forefront. And that's really all I can say about these situations. Very complex. Speak to a lawyer.